Hello friends, in the series on the income tax cases, today we will discuss a very important judgment of Honorable Allahabad High Court, which is regarding the search provisions. And the issue before the Honorable Court was that whether a search can be conducted on the assessee on the basis of the material which has been collected by the revenue after search, or if the revenue makes a search on the assessee on the belief that the notice will be issued to the assessee and he will not comply with the notices, and this belief is without any basis and which has not been recorded in the satisfaction note, whether that search is valid or not. This issue has been taken up by Honorable Allahabad High Court in the case of PRAMOD SWARUP AGARWAL versus Principal Director of Income Tax Investigation and others, and this case is reported in 477 ITR at page number 453, and the date of the judgment is 3rd June 2025. In the present case, a search was conducted on the assessee, and the basis of the search on the assessee was section 132 subsection 1 clause B, which talks about that if the revenue will issue the notice to the assessee, then the assessee would not produce or cause to be produced any books of accounts or other documents which could be useful or relevant for any proceeding against the assessee under the Income Tax Act. When the assessee filed the writ petition in the Allahabad High Court, the court observed that in the present case, the revenue didn't file any affidavit that the assessee at any time in his lifetime has avoided any revenue notices. And in the present case, on the facts of the case, it was very clear that the assessee has filed his income tax returns on time and always complied the notices issued by the revenue on time. So the Honorable Court was of the considered view that this was not a factor to be considered in initiating a search against the assessee. So the court quashed the search proceedings against the assessee and at the same time gave a liberty to the revenue that the revenue can initiate the proceedings under section 148 against the assessee if the law permits and if the revenue thinks that there is any escapement of income. In the present case, the court was also of the view that a search cannot be initiated against the assessee just on the reason that some two other shareholders have paid the tax on the same transactions in which the assessee has entered, and the assessee from the very beginning was of the view that these type of transactions are not taxable. The court said that although according to the Supreme Court judgment, the satisfaction not to be discussed very elaborately in the court, but at the same time, the court said that a search cannot be held valid just on the basis of the documentation and material recovered after search. The court said that the search cannot be held as justified on basis of post-search material collected from the assessee. The court also said that in the present case, whatever the supplementary documents have been collected by the revenue were not mentioned in the search, so it cannot be said that there was reason to believe on the date of the search. The court said that in the present case, various information has been collected from the assessee, various notices have been issued to the assessee under section 131 subsection 1A. The court said that for these notices, that once the action against the assessee has been completed under the provisions of section 132 subsection 1 clause I to section 132 subsection 1 clause 5, then in that case the notice or summons under section 131 subsection 1A cannot be issued to the assessee. Friends, this case is a very welcome judgment, because in many times it has been seen that even the searches, which is a weapon which is to be used only in the remote cases or in the exceptional cases, the revenue didn't hesitate to make the search very casually. So these type of searches are not valid. At the end of this video, once again I am repeating the name of the case. The name of the case is PRAMOD SWARUP AGARWAL versus Principal Director of Income Tax Investigation and others, and this case is reported in 477 ITR at page number 453, and the date of the judgment is 3rd June 2025. Thank you, friends.